So, history of trusts. As many of you will probably be aware that trusts were set up in England in the Middle Ages. This is a picture of a knight, because knights would go on a crusade, or a man would go off for some other reason, and he would leave his assets. He might leave his family company, his family heirlooms, the family estate, to a trusted friend to look after his family. Now, initially, 1,000 years ago, that arrangement wasn't legally enforceable. But over time, over hundreds of years, it became legally enforceable and became really what the trust is today. Because essentially now you have a settlor, i.e. the knight, who gives assets to a trusted person, i.e. the trustee, to look after for the beneficiaries, which is like the knight's family in this example. Interestingly, trusts, even in the 15 and 1600s in England, were also used for tax planning, because it was found that there were certain situations in which if assets were held in a trust rather than held outright by somebody, that would involve less payments being given under the feudal system of the time to the king. So anyway, the key thing is that now trusts have hundreds of years of history behind them, and that beneficiaries, if the trustee doesn't do what the trustee is supposed to do, the beneficiaries can take the trustee to court. So why use a trust today? Well, many of the reasons are still the same. We still use trusts for succession planning, particularly if you have a family business. Entrepreneurs like to set them up sometimes to avoid fragmentation of that business on their death. If they leave it to their children, those children might squabble about how to run it, and many, many businesses actually fail on the transfer to the next generation. So really, if anybody has a family business, then that they are a key candidate, really, for structuring with a trust. Another thing is avoidance of probate. We may all have very international clients. They have assets all over the place. Probate can be very complicated. If you transfer your assets to a trust instead, then no probate is required in respect of those assets on your death. Another reason is tax planning. Of course, we work with people from PwC, other tax advisors, to implement tax-efficient structures using trusts. We also use them for philanthropy. I don't just mean charities, I mean other philanthropic purposes that wouldn't count as charitable, or that would count as charitable, but the person who sets it up doesn't want the involvement of a charity commissioner or someone else who's going to meddle in in what the organisation is doing. They're also used for pre-IPO planning. They enable an IPO can take many years, and if during that time the founder of your company loses mental capacity or dies, then this can lead to the IPO being derailed. If you put the assets into a trust, that problem doesn't occur. So this, as well as other benefits, trusts are very frequently used for pre-IPO planning. And also they are increasingly used for asset protection. There's high-profile divorce cases. Of course, people can sign prenups, but not everybody will want to do that. You have a wealthy person wants to give assets to their child. They want to make sure that that child's spouse doesn't get their hands on too many of the family assets in the event of divorce. So they're used for asset protection too. Now, well, if we have a quick look at traditional trusts, key features of a traditional trust, well, the trustee has the power and also the duty to invest the trust fund to produce capital gain or a good income for the beneficiaries, or whatever it is that the beneficiaries need. They have a duty to do that. So therefore, they may have to sell trust assets if what they've invested in isn't performing. And they also, if the trustee owns a company, which they nearly always do, the trustee will need to be involved in the operation of that company. If the company's not performing, they may need to sell the shares of that company. Trustee, of course, in a discretionary trust, which is what most trusts are, they will have the right to decide when to give capital and income to beneficiaries. And also, beneficiaries have the rights to challenge the trust and rights to information in most kinds of trust. And another limitation of them is that trusts for non-charitable purposes are generally not possible with a traditional trust structure. In England, for example, there's extremely limited and obscure purposes that you can set up a trust for. So those are the key features of traditional trusts. They have limitations in the modern context. Settlors want control. They don't like to give their assets to a trustee and say, trustee, yes, do all of this with them, invest them, pay them out as you wish. People also have risky assets, such as family companies, real estate, art collections, car collections, that they want to transfer to trusts. And professional trustees don't necessarily want to deal with those assets. They don't know how to invest them. They don't want to have to sell them. The settlor doesn't want them to have to sell them. This is really like in the Middle Ages when they set up a trust. The knight didn't want the trustee to sell the family estate or the family business. People feel the same now. People also want to benefit non-charitable purposes rather than beneficiaries, whether that's in the philanthropic context or also in the commercial context that we'll look at. And the settlor doesn't want the beneficiaries to challenge a lot of the time. They don't want their beneficiaries to have rights to information and to be able to take the trustee to court. They want somebody else, such as themselves, to have that power instead. Oh dear, that's come out really faint, isn't it? Okay. I'll read out what it says. Trust laws of the progressive jurisdictions, such as Bvi, Jersey, Labuan. You can set up a traditional type trust in those jurisdictions, but you can also set up a trust with other sorts of features. For example, it is possible for the settlor or another person to reserve powers under that trust that the trustee would usually have. These are called reserved powers trusts. There are things called Vista trusts, or what I'm calling Vista-style trusts. We'll look at, again, in a minute. There are private trust companies. It's possible to set up your own company to be a trustee of a trust. So that is a very popular thing that we'll look at in more detail. Another aspect of the progressive jurisdictions is that they have things called firewalls, which can be used to deflect claims against the trust in various situations. And there are also non-charitable purpose trusts that are possible in all the jurisdictions that I'm aware of too, in some capacity. So now we're looking in more detail at each of those. So reserved powers trusts. These are where the trustee... Oh, by the way, I meant to say, if anybody has any questions, please do raise them while I'm talking. I like to have an interactive discussion if possible. So under reserved powers trusts, the trustee gives the settlor or another person of the settlor's choosing, usually called a protector, certain powers that the trustee would normally have in a traditional structure. So, power to invest, that's a very common one. It's possible in all of our jurisdictions to set up a trust where the settlor retains the power to invest rather than the trustee. Or the settlor just has the power to appoint an investment advisor. Sometimes the settlor will have the power to direct payments of capital or income, and the settlor may also have power to add or remove beneficiaries. In addition to these powers that the trustee would usually have, the settlor can also retain the power to revoke the trust during his lifetime, and he may also have power to replace the trustee. All these powers may be passed on, for example, after the death or the mental incapacity of the settlor. And I should mention that this is actually possible in the traditional jurisdictions such as England, but you don't normally do it because the position's not clear. There's a concern that if you have too many powers, it turns the arrangement into a nominee arrangement rather than a true trust.
Lara, in a practical scenario playing out, how would the relationship when there literally is a protector with so much reserved powers, how does the protector play into the trustee proper in a practical scenario?
Well, the trust deed sets out exactly what powers the trustee has and what powers the protector has. So the trustee can't really challenge this. And in fact, in a lot of cases, what we see most often is the power to invest. Trustees are actually quite happy to have someone else having power to invest, because that's the thing that trustees get sued for most, is misinvesting the trust fund. And so, in fact, trustee fees tend to be lower where the trustee doesn't have the power to invest, where the SEC law does. So, yeah, it works very well because there are no grounds for anyone really to challenge that.
Directors with different portfolio then, as such,
yes, I suppose it's like a board of directors, maybe where one director has a certain power, or where, yes, yeah. So sometimes it's helpful to have comparisons with companies. You have to be a little bit careful because there's important difference with trusts is you have this distinction between ownership and control, which you can have in a company, but you wouldn't have in a traditional kind of setup. So now we look at what I'm calling Vista-style trusts. I'm calling them Vista-style trusts. They originated in the BVI in 2003, called the Virgin Islands Special Trust Act. But now a number of other jurisdictions, including Labuan, have introduced these. I think they're a great invention. So you have set up such as here. And my arrows haven't come out. Anyway, there's supposed to be an arrow linking each of those boxes downwards. So you have a Vista-style trust, and you have a trustee of that trust. And the trustee will own a Vista-style company on the terms of the trust deed, and that company will own the underlying assets. I'm used to working with these in the BVI. It's probably similar in Labuan. The trustee in a BVI one has to be a BVI trustee, or has to include a BVI trustee if you have more than one trustee. And you have to have a BVI company underneath. So I expect that Labuan has a similar sort of principle. And Vista trusts, or Vista-style trusts, address an issue of traditional trusts that I referred to earlier, where the trustee needs to monitor the performance of a company owned as part of the trust fund, and they may need to sell the shares, intervene in the running of the company, and even sell the shares. There's been case law on that. So in a Vista-style trust, the trustee doesn't get involved. The directors run the company without interference from the trustee, except in very limited and extreme situations which the trust deed will spell out, but doesn't have to have any, actually. So the directors run the company. The trust deed usually will deal with the appointment and removal of the directors of the underlying company as well. Often it'll appoint somebody who can tell the trustee, I want to remove this person as director and I want to appoint this person as director. So key uses of these Vista-style trusts. Obviously, family companies. They're very much tailored to where you want to transfer a family company into a trust. And similarly for pre-IPO planning. You don't want a trustee to decide whether and when to sell the shares. You want your directors of your holding company to decide. So what you would have is you'd have your Vista-style company and you'd have your company to be listed underneath that. You often see a parent company effect. Risky assets. Effectively, this structure can be used to give the SEC law investment control. So it can also be used to remove the investment power from the trustee and give it to the SEC law, because the SEC law can be director of the company and making all the decisions as to what the company does. So these are often quite popular with trustees. So a lot of professional trustee companies won't deal with risky assets such as family companies unless they're in a trust like this. Now, private trust companies. Oh, another feature of Vista Trust that occurs to me, and I think they're actually very much in keeping with the origins of trusts, because I think when the knight went away in the Middle Ages, he didn't want his trusted friend to sell the family company. He wanted him to look after it so that his eldest son could run it. And similarly with the family home, he wanted that to be used for the children. He wasn't going to be too concerned about whether the value of the home was keeping up with the market or not. So private trust companies, what are they? Well, that's where you set up your own company to be trustee of your family trust. And they are set up because in many jurisdictions, all the ones I practice in, the trustees need a license to operate. But if the trustee is a company which complies with certain requirements, it'll be exempt from the licensing requirement. So in fact, you can set up a BVI Vista Trust with a private trust company, a BVI private trust company as trustee of that. But if you don't use a BVI private trust company, you need to use a licensed trustee. Now, requirements that the PTC needs to comply with do vary, but there's a general principle that the PTC must provide trust services to related trusts, such as trusts all settled by the same person or by members of the same family. And they're very popular because they enable the settlor and key members of the settlor's family to retain some control by being on the board of directors of the trustee company. Usually a PTC is a company limited by shares, so you need to give consideration as to who or what entity will own those shares. And this is a typical structure where you have a private trust company, so you have your trust down here, holding your assets for your beneficiaries. You have your private trust company as a trustee of that, with your director on the board, your settlor as director on the board. And the shares tend to be held by a purpose trust, a non-charitable purpose trust, with a professional trustee. There are other structures available. In particular, you can use a foundation, and we're going to look at foundations a bit later. You can use a foundation to hold the shares as well. So it's a more complicated structure. It's more complicated to explain to clients, but nevertheless, it can be very popular. Firewalls. Now, the laws of many of the progressive jurisdictions state that if an asset is transferred into a trust governed by my law, then I won't recognise the forced inheritance laws of another jurisdiction. By forced inheritance laws, I mean certain jurisdictions set out who you have to leave what to. Under English law, for example, you can leave all of your property, broadly speaking, to whoever you want. Under certain other laws, such as the laws of Taiwan, you can't. You have to leave a certain amount to your spouse, a certain amount to your children. Civil law jurisdictions tend to have these rules. They can also be very useful in the matrimonial context, because all of these jurisdictions will also they will limit the enforcement of judgments from a foreign court, including divorce judgments, so they can be very useful. Obviously, they do have limitations. Where the assets are is also a key factor, but they certainly make it a lot more difficult for people to bring challenges and to claim the assets of the trust. So obviously, key benefits are where if you have a settlor from a jurisdiction with forced inheritance rules, or if you want asset protection, for example, in the matrimonial context or in other contexts as well. So, non-charitable purpose trusts. As you will recall, the traditional position is that under the traditional jurisdictions is that a trust has to be set up for beneficiaries or for charitable purposes. The idea was that if you have a trust set up for purposes, it can't be enforced. So it can't be a true trust. but a public policy exemption was made for charitable purposes, but that wasn't extended to non-charitable purposes, even if they were philanthropic. And anyone who practices charity law will know that the charity laws are very tight, tend to be very tightly drawn. You need to have public benefit, for example, and you need to fall into certain, quite narrow categories. There's a lot of philanthropy out there that doesn't fall into the charitable definition. So progressive jurisdictions set up non-charitable purpose trusts. It's possible under all of those laws to set up a non-charitable purpose trust. And they get round the problem of the enforcement by having an enforcer as well as the trustee. So the trustee manages the assets and furthers the purposes, whatever those are. But an enforcer, if the trustee doesn't do that, it's the enforcer that takes them to court. There's no beneficiaries to take them to court, so the enforcer does. Makes sure that the trustee does what it's supposed to do. So obviously key uses include philanthropy. But they're also very widely used for commercial purposes, because it's possible to ring fence an asset to keep it off the balance sheet, for example. If you want to obtain some funding for a particular project using a particular high-value asset. And as we saw earlier, they can also be used for holding the shares in a PTC.
Laura, just to interrupt, I mean, you just previously used the word protector, and now for non-charitable, you use the word
enforcer. It's different.
But terminology is
it's not just terminology. Enforcer is actually the term used in legislation. Protector is a loose term that doesn't tend to be defined. An enforcer is defined, and the enforcer, there is a difference, because an enforcer actually has a fiduciary duty to enforce the purposes of a...
protector is a role sculptor now?
Yeah, that's a friend, either the settlor himself or maybe a friend of the settlor, just to ensure that the settlor's wishes are complied with. And it's not usually wanted that it is a fiduciary role. So this is a duty to enforce it's sort of instead of the beneficiaries having that. Yeah, the statutes provide that there has to be an enforcer. Yeah, and they all of the ones. I don't know what Labuan uses. Yeah, they're called enforcers, right?
What is the definition as enforcer? The definition individual?
It can be. It can be an individual. Yes, it can be an individual. It can be a company. They're usually very. It's not very specific as to who the enforcer needs to be, but it is the person who will hold the trustee to account. If the trustee is not furthering the purposes, for example, you might set up a purpose trust to. Let's see. Well, an example I've got later is somebody they buy a bit of land and they want it to be a playground for the children in their block. If the trustee bought the land but never bothered to develop it for that purpose, the enforcer can take the trustee to court and force them to. So now I thought it would be helpful to look at some examples. And maybe we can, from what we've looked at before, we can discuss the sort of features that client might be looking for, the kind of structures you might suggest to your client. So on the right, I've just got a little summary of the ones we've discussed: reserved powers, Vista, private trust companies, firewalls, and having a non-charitable purpose trust. All the key things we just discussed. And on the left, I've got some examples. So if you have a client, this is quite a common one. A client has a portfolio of assets. He wants to transfer those assets to a trust for himself and his family. But he doesn't want the trustee to make the investment decisions. He wants to make the investment decisions himself. So what sort of things might we be looking at there for that client?
Reserve powers.
Yeah, reserve powers. We could also be using a Vista trust, and we could have a PTC with the client as one of the directors of that PTC. So now two. Client has founded a private company. And he wants to transfer the company to a trust for his family. And he's planning an IPO. What sort of trust would we set up for that client? Vista, usually Vista, a Vista type trust, yes. You can do it with a reserved powers trust as well, but I usually go for Vista in this case. Thirdly, client's son is getting married. He says, I'm really worried. He comes to you and says, I'm really worried. You know, I've got all this family wealth that I've built up over the generations. He's marrying a gold digger. She doesn't love him. She's going to divorce him in a few years. Firewalls. Yes, so you're looking for the firewalls, yes. I've had this one, actually. Yeah, and of course, she wouldn't sign a prenup, and of course, the son said, well, of course she won't. Yeah. Yeah, we get quite a lot of these. Yeah. So, number 4, client is from Taiwan. What does Taiwan have? It has forced inheritance rules. You can't leave your assets to whoever you want. You have to leave a certain amount to certain children. Client's fallen out with his daughter, so he wants to leave most of his estate to his son. Now, he can't do that under Taiwan law. So what are we going to be looking at there? We're going to be looking at, yeah, sorry, I can't hear in here, but, firewalls again. Well, I can hear you, I can't really hear anyone. We need to pass the microphone around. Yeah, so you want to use the trust law of a progressive jurisdiction here, not a traditional trust, because that will help to ensure that if there's a challenge afterwards, it won't be implemented. This is the example I discussed earlier. A client has a small piece of land next to his block. He wants to convert it to a playground for the children of his block. That's probably too narrow to count as a charitable purpose, which is why I've chosen that. So I was just trying to get at what kind of trust you would have. So you'd go for a non-charitable purpose trust there. Yeah. Now you have this is a common one that we see as well. You have a corporate client. They have a particular deal. They're buying a ship. They want to, very, very expensive. They need to get funding for that, but they don't want that ship to be on the books of the company because they don't want the rest of the company assets to be at risk. It's for a specific project, usually short term. So does anybody know what kind of trust you'd set up there? Sometimes Vista. Yeah, sometimes Vista. Usually we use purpose trusts for that. Because you set up the trust, so that the purpose of the trust is holding the shares in this company that owns the ship for implementing your business plan, and you have your business plan attached.
I just realised if I look closer, the
answer I did. I forgot to delete them. This is my annotated version. I think I forgot to delete them from this particular slide, but they're very faint anyway. So probably nobody further back can see them there. Now, what about this one? Clients, this is also very common. Clients say, I want to set up a trust, but I don't want beneficiaries to have any rights of information. They mustn't be able to challenge the trustee. This is actually a trick question, because none of these examples that we've looked at will provide that. In all of these trusts, the beneficiaries do have the right to challenge, and they have rights to information. There is one type of trust, a Cayman Star Trust, can be used in this situation, but so can foundations. Jersey, Guernsey, Labuan foundations, well, I assume Labuan foundations can be used where the beneficiaries of that entity don't have the rights to challenge. So now, how to set up a trust? I've said don't put the cart before the horse. Because I get so many clients and advisors coming to me saying, I want to set up a Cayman trust, how much does it cost? Rather than coming to me saying, this is my goal, I want to achieve this, how best to do it. Now, if you've got a very well-educated client, they might know, but they don't usually. Usually it's best that they come to you and you can make recommendations to them, or I can make recommendations. Somebody who knows about the different structures. So, as I've said, firstly, discuss what the client wants to achieve, and you need to discuss, or I will always need to discuss the client's background, their family, who might bring challenges, what their citizenships are, their tax residence, their domicile, that kind of thing, because I'm probably going to need to get tax advice, as I mentioned at the end. I need tax advice and disclosure advice in all the relevant jurisdictions, especially if somebody comes from or has links with a very high tax jurisdiction such as the US. Oh, thank you. Now, a trust lawyer or another structuring specialist should design the structure. Some trustee companies are very good at doing this as well, but somebody who knows what they're doing either needs to design the structure or should review it to make sure it works, make sure it does what the client wants, and also to look out for any risks that there are. Who might, might it be easily challenged? What sort of pitfalls might there be? And that person should be able to recommend amendments if necessary. And as I mentioned before, you need tax advice and disclosure advice. The world is becoming increasingly transparent. More and more information is required to be disclosed. We need to make sure that we all comply with that. And the only way that we can do that is by getting advice from the experts, such as our colleagues in PwC, who can advise on that. And you do it at all key times: before you establish the trust, before transferring assets to the trust, on distributions to beneficiaries, and on any material changes in circumstances, such as adding a beneficiary, or if a beneficiary moves to a different jurisdiction. Sometimes you actually might want to exclude them as a beneficiary, for example, if they move to the US. Now, pitfalls. Now, one that we commonly see is that settlors want to maintain control, but sometimes they want to maintain too much control. Now, you can do that without the trust being invalid on the face of it, but it can give rise to the challenge that the settlor didn't intend to create a trust in the first place. When you set up a trust, there are three certainties that you have to comply with. You have to have certainty of beneficiaries, certainty of the trust fund, and certainty of intention. The settlor has to want to create a trust. And so it is possible, if there are too many powers, that somebody might say, well, hey, the settlor didn't intend to create a trust here. Now, the reserved powers might be very obvious. They might be through reserved powers in the trust deed, but they can also be where you have, for example, the settlor is the sole director of the private trust company. So that's something I would always avoid, and especially avoiding sole directorship and ownership by the settlor of the private trust company shares. Even if there's not a challenge in respect of intention, lots of reserved powers can undermine the benefits of the structure. If you want to achieve asset protection, you can't make a trust revocable, for example. You can't have the settlor being able to appoint capital or direct where the capital goes. And really, most practitioners now agree that you can't have the settlor being able to appoint and remove the trustees either. Doesn't mean that the settlor can't have these powers at all, but it's much better for them to be consent powers. It's much more difficult to bring challenges if all the settlor has is a power to consent, or alternatively, if you have a panel of protectors which can include the settlor, so that the settlor still has influence and power, but it's diluted by other people. So another one, this is very similar, and in fact a lot of practitioners confuse these two, and it doesn't really matter from day to day, but technically sham is a different thing than having too many express powers. This is where settlor sets up a trust. It may be a very vanilla trust where the trustee has all the powers, very traditional style trust, but in fact the settlor and the trustee agree that whenever the settlor needs funds, all he needs to do is phone the trustee up, and the trustee will say, okay, where shall I pay these funds to? Oh dear. Where shall I pay them to? Thank you. Now, that sort of arrangement, there is case law on this, can be held to be a sham. So the trust was never actually created. That sort of claim can be brought, like the other claim, can be brought by, it might be brought by a tax authority. It can be brought by a creditor who's trying to get his hands on the trustee assets, a divorcing spouse. It might be from somebody from the settlor's family who was excluded but thinks he should have been included. All sorts of people can bring a challenge to a trust, and you might not know who they are now. Family rifts can happen in the future. So if you set it up properly and run it properly, this minimises these sort of challenges. So if a settlor wants to reserve powers, it is actually better that they're put in the trust deed. Obviously, don't have so many that it can be deemed not to be a trust at all, or not to be intended to create a trust. But if you include certain powers in the trust deed, some as consent powers, some as express powers, that will help to avoid any claim that it's a sham. Now, another thing that we see a lot, we see inappropriate use of private trust companies. Now, this is something that practitioners discuss informally a lot. We see a lot of private trust companies set up really where there aren't appropriate people to be on the board of that private trust company, or where they are inappropriate in other ways. They can be very useful. If you have very high value trust fund, it can save money. They can be used for the settlor to have control. If you have family offices, you will usually have private trust companies. But you do need to take care of the structuring. You need to avoid the settlor being sole director, for example, I would say. And you also need appropriate directors, not just now, but these are long-term structures probably. So you need to think of who's going to be directors after the settlor dies. And after you might have siblings on the board. After those siblings die, even after the children die, you need to have some sort of plan. And you have to remember that a PTC is still a trustee. It has the same powers and duties that any other trustee can have. It can still be held to account by the beneficiaries for getting things wrong. So you will need professional involvement or advice. Now, the professional involvement can come in the form of a professional director on the trust company board, or might come just in terms of giving professional advice. So I would always consider, if you think there's going to be a problem with a private trust company, consider using reserved powers instead. Usually the settlor will have wanted to set up a private trust company because they want involvement, they want to be on the board. If you think it's going to be a problem, you can give the settlor reserved powers instead, and that structure is much simpler, and will be cheaper to establish and probably to run. So other potential pitfalls: unexpected tax consequences. Of course, if you haven't had appropriate tax advice. For us advisors, non-compliant clients. Now, in some parts of the world, tax evasion, for example, is the norm, so rather than the exception to it. So we need to be very careful that we are not facilitating that as advisors. So obviously getting appropriate tax advice helps, and asking all the right questions. It's getting more and more difficult, isn't it, for trustee companies? You need to be really sure that you know the source of the client's funds and that everything has been declared and so on. But another point is trustees. Very commonly, I've seen trustees unquestioningly following the instructions from the settlor and not keeping adequate records. And so what's the problem if the trustee follows the instructions from the settlor? Settlor using it as using a trust fund as a bank account can be treated as a sham. So now, foundations. I need to hurry up a bit, don't I? Sorry. Now, foundations are a corporate entity, unlike a trust, which is where you have a trustee holding assets for beneficiaries. The trustee will always enter into contracts there. Here you have the foundation itself entering into contracts. Now, they can be set up for beneficiaries or for purposes or for both. They offer avoidance of probate, avoidance of forced inheritance rules, many other benefits of a trust, asset protection. So really where you can use a trust, usually you can use a foundation instead. There are some key differences. One is control. As we've seen, a trust is controlled, is run by its trustee. A foundation is controlled by its council. The founder can be on that council, so this can be a simpler alternative to a PTC structure. The founder can have control. Another issue is enforcement, and I think this is going to be a very popular one with clients here. The foundation can be set up so that the beneficiaries don't have the rights to enforce it. They don't have rights to challenge, and they don't have the right to information. Instead, you have somebody, in Jersey and Guernsey anyway, you have somebody called a guardian who has that right, who plays a role like an enforcer, really, in a purpose trust. And one thing I think is very useful about foundations is we've seen the issues of sham, lack of intent to set up a trust. Now, with a foundation, you don't have to, I don't think you really have to worry about that. Because all you have to do is comply with the statute. It's a statutory thing. So once you've complied with that and you've registered the foundation, in Jersey and Guernsey they need to be registered, I think it's going to be extremely difficult for anyone to say that it doesn't exist. I think it probably is going to be impossible. So I think this gets round these problems that we can encounter with trusts. However, trusts, of course, have this long history, hundreds and hundreds of years. Foundations are newer, although, as I said earlier, they were actually first established in Liechtenstein in 1925. So they're not quite as new as people think, but they are certainly newer than trusts. Uses of foundations, really you can use them for whatever you use trusts for. You can use them for charities and non-charitable purposes, such as philanthropy, or for holding an asset in the same way that a purpose trust could be. They're used for succession planning. They can be the trustee of a trust directly, or they can hold the private trust company shares. Now we just have a brief recap. So the first step always has to be discuss the client's goals first, and then you discuss the client's background, and then you work out what structure is going to suit them and what other advice you need to take. Consider using the progressive jurisdictions as governing law of the trust if the client wants to retain control or to settle risky assets such as a family company. To benefit non-charitable purposes, you'll probably have to use a progressive jurisdiction then. Or if you want a regulated trustee, most of these jurisdictions require their trustees to be regulated, which can be very reassuring to clients. And they're also helpful for asset protection because of the firewalls. Also consider foundations. For example, if a trust doesn't work, or to consider a foundation anyway. And I think a foundation is a great invention. It enables the settlor to retain control, but without having these questions of sham and invalidity. They can be used to benefit non-charitable purposes, and they can be also used to limit beneficiary rights to challenge and beneficiary rights to information, which a lot of people want. Make sure you get appropriate legal advice if you don't know it yourself. Does the structure do what's intended? What are the risks and how can they be minimized? And get tax and disclosure advice if any is required to make sure that everyone is complying and there are no nasty pitfalls waiting for you.